Good afternoon, and welcome again to the State and Local Legal Center's webinar on North Carolina State Board of Dental Examiners versus FTC. I'm Lisa Sornin, Executive Director of the State and Local Legal Center. A few housekeeping matters before we begin. First, thank you to the National Conference of State Legislatures Legal Services Staff Section for hosting this event. During the presentation, you will be able to ask questions by typing them in the chat button and pressing send. A recording of this webinar will be available on the SLLC's website following the event. There are two handouts associated with this webinar. You may obtain them in the media library on the upper right-hand side of your screen. The views expressed in this webinar do not necessarily reflect the views of the SLLC member groups. For those of you who are new to the State and Local Legal Center, the SLLC files amicus briefs before the U.S. Supreme Court on behalf of its members, comprised of the Big Seven national organizations representing the interests of state and local government. These groups and the SLLC's two associate members are listed on this slide. Since 1983, the SLLC has filed over 300 amicus briefs. This term, the SLLC will file at least 8 briefs before the Supreme Court. The SLLC is a resource for Big Seven members on the Supreme Court, and this webinar is an example. Now I will introduce our speakers. Geoffrey Green is the Assistant Director with the Bureau of Competition at the Federal Trade Commission. Sarah Oxenham Allen is a Senior Assistant Attorney General in the Antitrust Unit of the Virginia Attorney General's Office. Geoffrey, you may begin.
Thank you, Lisa, and good afternoon. My presentation today is in 2 parts. The first part addresses the policy and legal theory underlying the active supervision requirements. This is my attempt to answer the question that many are asking, namely, how is it possible that the antitrust laws require one state entity to be supervised by a second state entity? Part 2 addresses the nuts and bolts of the active supervision requirement. Before we start, I'd like to thank the National Conference of State Legislatures, the State and Local Legal Center, and the Legal Services Staff Section. Thank you for organizing the event, and thank you for inviting me to participate. My final preliminary notice is an important and sincere disclaimer. This presentation expresses my views. It does not necessarily represent the views of the Federal Trade Commission or of any individual commissioner. If you go to the Federal Trade Commission website, you can find a link to the agency's antitrust complaint mailbox. Anyone may send to the agency an email reporting a suspected antitrust violation. To set the stage for this discussion of the active supervision requirement, let me describe in redacted form some of the complaints received by the FTC over the past several months concerning state regulatory boards. One group of emails addresses requirements for the issuance of a license, requirements that the complainant believes are unreasonable. Commonly, the complainant is relocating from one state to another and is finding the regulatory board in his new home to be unwelcoming. One email said, "I have been licensed in State A for several decades to engage in a construction trade. I have worked my way up to supervisor, and when I relocate to State B, I hope to find a new job as a supervisor. The licensing board in State B says that I have to serve initially as an apprentice. Serving as a supervisor does not require physical strength, but serving as an apprentice means in part carrying very heavy supplies around a construction site. I no longer have the strength to do this, but I am fully capable of serving as a supervisor. I should not have to serve first as an apprentice." A second category of complaints relates to actions defining the boundaries of a profession. One complainant says, "For years I have provided counseling to parents in my church and community who have a child with a substance abuse problem. I have recently received notification that in order to continue providing this service, I need to be licensed as a social worker." The email says that the religious-based counseling that the complainant is providing is unlike the services by a social worker. I describe these complaints in order to drive home this point. The word is out that the actions of state regulatory boards may be subject to antitrust challenge. The number of complaints about state regulatory boards submitted to the FTC is increasing, and aggrieved persons are also talking to private attorneys. It follows that if state legislatures, attorneys general, and state boards are reviewing how to address antitrust issues in light of the Supreme Court's NC Dental decision, this is time well spent. To a representative of a regulatory board, I suspect that the complaints I just described about being excluded are routine and expected. Competitor exclusion is at the heart of a licensing program. Licensing is an effort to divide would-be providers into qualified and underqualified. Underqualified providers are denied a license and barred from competing. Board members are exercising their judgment and discretion, and some excluded persons are bound to be unhappy. Now let's ask, how do these complaints sound to an antitrust lawyer? The concept of exclusion is also central to antitrust analysis. Antitrust law views exclusion as a commonly used mechanism of competitive harm. If you exclude new entrants or force rivals to exit the market, then the incumbent suppliers may be able to raise prices. If you exclude low-cost providers of a service, again, the result may be higher prices for consumers. If you exclude innovators, then the quality and range of available services may be lessened. So competitor exclusion is suspect under antitrust law, but essential to licensing. This gives rise to a potential conflict between antitrust and regulatory programs. How is this conflict between state regulatory policy and federal antitrust policy resolved? What law has primacy or precedence in the event of a conflict? The answer is found in a body of court decisions referred to as the Antitrust State Action Doctrine. The leading cases are cited on the slide. I'm going to provide a very quick overview of the law. The central precept of the State Action Doctrine is this. In passing the Sherman Act, Congress did not intend to prevent states from regulating their own economies, or even from adopting anti-competitive forms of economic regulation. Stated affirmatively, a restraint that represents or constitutes the regulatory policy of the state will be exempt from antitrust liability. Now that sounds rather simple. Complexity arises when courts operationalize this general precept. The legal rules depend upon the identity of the relevant actor, who is doing the regulating, who is the decision maker. At the top of the hierarchy are the sovereign institutions of state government, the state legislature and the state's highest court. For the moment, I will focus on the state legislature. The official acts of the legislature necessarily represent the regulatory policy of the state and are always exempt from antitrust liability. But as a practical matter, the legislature cannot alone oversee all aspects of economic regulation. Instead, the legislature often sets broad direction and delegates authority to other entities and institutions such as regulatory boards. And as you know, some regulatory boards are made up of market participants, dentists regulating dentists, or accountants regulating accountants. This delegation of policymaking discretion to market participants is critical to understanding the state action doctrine. The market participants have a private financial interest in restraining competition that may conflict with the policy preferences of the state. As a result, an antitrust court cannot be confident that restraints adopted by market participants faithfully advance state regulatory policy. In order to invoke the state action defense, the actions of the market participants must be actively supervised by the state. I have said that the key to understanding the requirement for active supervision is to understand that antitrust courts are uncomfortable with policy discretion being exercised by market participants. The NC Dental case provides a good illustration of what is meant by policy discretion. The North Carolina legislature has delegated authority to regulate dentistry to a board consisting largely of practicing dentists. The issue in this case was defining the boundaries of the profession of dentistry. Non-licensed persons were providing teeth whitening services in malls and salons in competition with the state's licensed dentists. Dentists complained to the state dental board. The North Carolina Dental Act prohibits the practice of dentistry except by persons who are licensed by the board. However, the statute is silent on whether this prohibition covers teeth whitening. The relevant practice bleaching teeth with peroxide did not exist when the statute was first enacted. Therefore, the determination of whether non-dentists may lawfully provide teeth whitening services requires interpretation of generally worded statutory provisions. Exercising its discretion, the board decided that in North Carolina, teeth whitening constitutes the practice of dentistry and directed non-licensed persons to cease and desist. The discretionary act excluded non-dentists, reduced consumer choice, and raised market prices. As the board's discretionary action was not actively supervised, the state antitrust action defense was inapplicable. Slide 6 is a recap, perhaps suitable for framing. Question: what is being supervised? Answer: the exercise of policy discretion by market participants. Question: why is supervision necessary? Answer: the antitrust court cannot be confident that the actions of market participants necessarily further state policy. Question: what is the purpose or function of supervision? To ensure that the restraint at issue advances state policy as opposed to private interests. Question: why is this distinction important? Answer: antitrust enforcement defers only to the policy preferences of the state, not to the preferences of private actors. I have discussed why supervision of market participants is required. The next issue is, what does this supervision look like? The Supreme Court's Hoover decision provides an illustration. The setting in the Hoover case is a licensing program for attorneys. Plaintiff was a law school graduate seeking admission to the Arizona bar. The plaintiff received a failing grade on the bar exam and was denied a license. Defendants were members of a state agency called the Committee on Examinations and Admissions. This is a group of licensed attorneys, that is, market participants, appointed by the Arizona Supreme Court and tasked with administering the bar admissions process. The commission was responsible for grading the examinations, a task requiring the exercise of judgment and, yes, discretion. Plaintiff's antitrust claim was that the committee adopted a grading formula designed to limit the number of successful applicants and to do so without regard to competence. The allegation was that grading was manipulated and that competent applicants were rejected in order to protect incumbent attorneys from competition. The U.S. Supreme Court rejected this antitrust claim because the committee was closely supervised by the Arizona State Supreme Court. Recall that the highest court in the state, like the legislature, is considered sovereign and exempt from federal antitrust laws. The Arizona Supreme Court specified the subjects to be tested and required the committee to submit its grading formula to the court in advance of each examination. The committee recommended applicants for admission to the bar, but the court made the final decision to admit or reject each applicant. In addition, a disappointed applicant could seek individualized review of his application by the court. In sum, the party responsible for excluding the plaintiff and other allegedly competent law school graduates was not the practicing attorneys on the committee, but rather the Arizona court. The Arizona court was said to be, quote, the real party in interest. Here is what we learned from the Hoover case. First, this is an example of a state licensing authority that is effectively supervised. So plainly it can be done. The members of the Arizona Supreme Court did not have to grade the bar exams. It was enough that the actual graders, the market participants on the committee, were closely monitored. Second, we get an important insight into how best to defend an antitrust claim against a state regulatory board. If I am a regulatory board that has excluded would-be competitors, I would like to be able to say to the antitrust court, it wasn't me. The board was not responsible for this allegedly anti-competitive act. Sure, the board advised, the board implemented, the board assisted, but it was the supervisor that ultimately made the decision. The real party in interest was the supervisor, therefore dismissed the antitrust claim against the board. Now, I'm not saying that supervision of a regulatory board needs to be structured the way it was in Hoover, but if you want to be safe and conservative, perhaps the best way is to adopt a regulatory structure that puts the onus for any allegedly anti-competitive conduct on the supervisor. Now let's discuss the FTC Staff Guidance. The impetus for the issuance of staff guidance was communications from state officials to the FTC after issuance of the Supreme Court's decision in NC Dental. State representatives said to the FTC, in essence, "You guys created this problem, help us to solve it." FTC staff issued this guidance document in October 2015. In part, this document is intended as a useful resource and reference. We identify the leading cases and define the concepts. Even if you do not like our advice, you may find the document to be a good starting point for further research and analysis. The term guidance is chosen deliberately. States are not obligated to follow the staff guidance. Actions inconsistent with staff guidance do not necessarily violate the antitrust laws. The guidance addresses the nuts and bolts of designing a program of supervision. The first question is, who is an active market participant? According to the staff guidance, the category of market participants includes a person licensed by the board and also a person who provides any service that is subject to the regulatory authority of the board. A person who temporarily suspends active participation in an occupation for the purpose of serving on a state board will be considered an active market participant. This is intended in part to prevent a person from gaming the system, claiming Tuesday I am a dentist, Wednesday I am a disinterested regulator, Thursday I am again a dentist, benefiting from the anti-competitive actions of the board. Staff made the pragmatic judgment that a board member who intends to return to active practice is susceptible to the conflicts of interest that the Supreme Court was concerned with. Staff's answer to the question, who is an active market participant, is arguably under-inclusive. Justice Alito's dissenting opinion in NC Dental raises the question of whether forms of regulatory capture, separate from staffing the board with market participants, should trigger the need for active supervision. The Supreme Court majority had nothing to say about regulatory capture. One possibility is that the majority is simply leaving the question for another day. The question was not presented or briefed in the NC Dental case, so there was no reason to resolve the question. That said, there is a strong argument to be made that Congress did not intend for the antitrust laws to root out corruption or regulatory capture. Beyond this, it would be difficult to design and administer a test for the presence of regulatory capture. The concept is vague and subjective. The proposed definition of active market participant is arguably over-inclusive in that it implicitly assumes that a market participant serving on the board will have a conflict of interest when it comes to each instance of regulating the occupation. In reality, the members of a licensed occupation may be diverse in terms of what they do and where they practice. Suppose that a board member participates in the occupation that the board regulates, but does not have a financial interest in the challenged restraint. For example, we may have dentists who work upstate in the northern part of the state regulating downstate, and dentists who work downstate regulating upstate. Or a restraint may apply to an occupational specialty not practiced by members of the regulatory board. For example, a particular restraint on legal practice may apply only to the practice of real estate law, and none of the lawyers serving on the board are real estate lawyers. The position of the staff guidance is that if a board member holds a license from the board, then he is a market participant for all purposes. There are several justifications for this. First, this rule addresses a concern about log rolling. we don't want to permit a situation where the upstate dentists protect the downstate dentists from competition, and in exchange, the downstate dentists protect the upstate dentists from competition. Second, staff's guidance reflects a recognition that any individual's scope of practice is fluid or changeable. The practitioner could move north to south from corporate law into real estate law. So even if there is no obvious conflict of interest, there may be a latent conflict. The alternative of asking whether the board member has an actual financial conflict of interest is unappealing. The antitrust court or antitrust agency would potentially need to conduct an audit of the members of the board to determine whether the member has an actual or potential financial interest in the restraint at issue. Finally, staff's guidance on this issue, defining active market participant, is consistent with the language of the NC Dental case and reflects the implicit rule in the Supreme Court's Goldfarb decision. Suppose that some members of the state regulatory board are active market participants and that some members are not active market participants. They are, in a sense, independent. How does one determine whether active market participants control the board? The staff guidance says if market participants make up a majority of the members of the board, this is sufficient to trigger the active supervision requirement. But majority status on the board is not the only way to exercise de facto control over decision making, and de facto control is sufficient to trigger the active supervision requirement. There are two primary scenarios of concern here. First, market participants constituting a minority may usurp the authority of a regulatory board. For instance, they may exclude the independent members from participating, withhold information, meet separately, act surreptitiously, or act contrary to state law. So scenario one contemplates some improper conduct by the market participants on the board. Scenario two contemplates some improper or negligent conduct by the independent members. The independent members may fail to safeguard the interests of the state because they are disinterested, apathetic, inactive, or overly differential to the market participants. In both these scenarios, a numerical minority of market participants may in fact control the regulatory board. And again, where the market participants control the board, the active supervision requirement is applicable. If we conclude that a particular regulatory board is controlled by active market participants and that active supervision is required, what constitutes active supervision? The state's supervision mechanism should provide realistic assurance that the board's conduct promotes state policy rather than the interests of the market participants. As a start, the supervisor must have the power to veto or modify particular decisions to ensure that they accord with state policy. If the supervisor merely rubber stamps the actions of the board, this is not active supervision. I refer you to the Supreme Court's Tycor decision. How does an antitrust court determine whether the supervisor has been conscientious as opposed to acting as the proverbial rubber stamp? The staff guidance identifies relevant factors, some markers that the supervision has been serious. First, consider whether the supervisor has sought and obtained the information necessary for a proper evaluation. The supervisor should not necessarily be limited to the information gathered by the board that is being supervised. Second, consider whether the supervisor in fact evaluated the substantive merits of the board's recommended action and determined whether the recommended action comports with the standards established by the state legislature. Third, consider whether the supervisor has issued a written decision explaining the rationale for its actions. These steps are perhaps not necessary in all circumstances. There may be other ways to establish and evidence active supervision. But if the supervisor does these three things, you are reasonably safe. In reviewing commentary addressing the NC Dental decision and the FTC guidance document, I have seen one area of confusion and uncertainty. This is the question, what are the criteria by which the state supervisor should evaluate the discretionary actions of the regulatory board? First, Supreme Court decisions make clear that a substantive review of the board's action is required. The supervisor must review the substance of the decision, not merely the procedures followed by the board to produce it. In this substantive review, the supervisor may employ a consumer welfare standard as an antitrust law, but is not required to do so. The legislature may instruct the supervisor to preference incumbent suppliers. The legislature may instruct the supervisor to preference health and safety without regard to cost. The policy objective can be whatever the state sovereign directs, except that the state may not direct the supervisor to defer to the policy preferences of the board. Suppose that a supervisor approves or is required to approve a proposed restraint on competition based on a finding that the board's actions were within the discretion delegated to the board by the state legislature. This likely is not active supervision. The Supreme Court's concern in NC Dental is not that the board has acted outside its statutory authority. Rather, the concern is that in exercising its discretion in addressing matters left open by the state legislature, the board promoted the interests of its dentist members instead of promoting the interests of the state. Any supervision mechanism in which the supervisor is obliged to defer to the legal, factual, or policy conclusions of the board poses a risk. The discretion of the supervisor should not be circumscribed by the board that it is supervising. So in my judgment, the supervisor cannot be bound to uphold the board solely because the board's actions are judged reasonable, or solely because the board's actions are judged not arbitrary and capricious. What is required is more akin to a de novo review. Last issue, who may act as a supervisor? The Supreme Court has expressly instructed that the supervisor may not be an active market participant. Subject to this constraint, states have a good deal of flexibility. The tough question for states is not who legally may serve as supervisor, but rather what entity or institution is best suited to serve this function. Recall, this is essentially a policy-making function. You want some entity with the skills, resources, and competence to serve as a policymaker. Several states have within the executive branch an umbrella state agency that has authority over the state's occupational licensing boards. Where such an agency exists or can be created, it seems sensible to have that agency serve as the supervisor for state action purposes. Alternatively, supervision can be a responsibility of the Office of Attorney General. Consider, however, whether this will be disruptive to the relationship between these parties. The ordinary responsibility of the AG, as I understand it, is to be attorney for the board. Acting as supervisor is a very different role. In some states, a legislative committee is empowered to review agency regulations. There are reasons, however, why legislators may not be the best suited to act as the state action supervisor. In the event of an antitrust challenge, the supervisor needs to be able to answer questions about the process, perhaps at trial and in a deposition. What steps did you take to evaluate the proposed regulation? What information was available to you? What information did you consider? Elected officials may not be accustomed to or comfortable with answering these types of questions. If the supervising entity wants to minimize the need for this sort of post hoc inquiry, one strategy may be to maintain written records, including issuing a written opinion. Finally, states may consider whether courts would be an effective supervisor. The state action review process is different from the review process that courts are accustomed to. As discussed earlier, the supervisor is not checking that the board has acted reasonably or lawfully. The supervisor is in a policy-making role. Judges are accustomed to making policy when regulating the legal profession. They may not be equally comfortable as a regulator of the medical profession, accountants, the construction trades, etc. I think that I have now hit the highlights of the FTC Staff Guidance. I'm going to stop here and turn the floor over to Sarah Allen. We may have time for questions following Sarah's presentation.
Thanks, Geoffrey. This is Sarah Allen in Virginia, the Virginia AG's office. I also want to thank the organizers for organizing this important webinar. I think there are a lot of people out there that are confused and worried about this decision and the effects it will have on state government. And there's no real clear answer, as you've heard, about what is the right way to construct adequate active supervision. So I appreciate being asked to participate. I also want to do a similar disclaimer to Geoffrey that the things I'm saying here today are not necessarily the opinions of the Virginia Attorney General's office or of general hearings. And with that, I will, oops, I went too far. Sorry. As Geoffrey pointed out on an earlier slide, the Supreme Court held in the Town of Halley case that only the clear articulation arm of the Mid-Cal test had to be met in order to have state action immunity for municipalities. It was widely believed, although never specifically held, that the same requirement of only having to meet the clear articulation arm also applied to subordinate state entities like traditional state agencies, the Department of Transportation, the Department of Human Resources. Also, professional licensing boards were considered to be subordinate state entities that only had to meet the clear articulation arm. The characteristics of the boards that reinforced that perception were that they were created pursuant to state law by the state sovereign, mostly the legislature for the executive branch agencies, but also the state Supreme Court for the bar and the bar examiners. They were within umbrella traditional state agencies, such as the health regulatory boards being within the state's Department of Public Health. The board members were often appointed by the governor and could be removed by the governor for cause, although in the North Carolina dental case, the board members were elected by the professionals that they were regulating, which is a factor that one of the Fourth Circuit judges in the North Carolina dental case found significant. However, the Supreme Court case in North Carolina dental found that the method of determination was not significant. The professional boards also had rulemaking review pursuant to the State Administrative Procedure Act, which often requires approval by either a cabinet secretary and/or the governor before these rules could go into effect. Disciplinary decisions were subject to administrative and judicial review, also usually through the state APAs. They had public board members, and there seemed to be a national trend over the last 10 years for boards to increase the layperson representation on their professional regulatory boards, but they still represented the minority of members on the board. And the meetings and records were subject to open government laws and FOIA requests. In light of the North Carolina dental decision, I would have to say that although these all do still apply to these boards, that they are no longer relevant as to whether or not they need active supervision. Sorry, this next slide, I didn't remove the code to do these cases one by one, but in the wake of the North Carolina dental decision, states have already started seeing many antitrust challenges in federal court to board activity that is not actively supervised. This is a list of the cases that I am aware of that have been filed since the North Carolina dental decision. None of these cases were brought by the FTC, who is the entity that brought the North Carolina dental case. These were all brought by a licensee or a potential licensee of the board who claimed and the licensee or potential licensee claimed that the board's action against him harmed competition for a broader class of competitor that he represented, and it wasn't just harm to the licensee. Almost all of these cases, except for the Teladoc versus Texas Medical Board case, have had either the complaints withdrawn, they have settled, or they have had the defendant board's motions to dismiss the cases granted. As a matter of fact, the Connecticut case, Robb versus Connecticut Board of Veterinary Medicine, had their motion to dismiss granted yesterday, and the Puerto Rican case noted there had their motion to dismiss granted on December 29th. So these are very recent. Very few of these cases have stated a credible underlying antitrust claim, so active supervision hasn't really been the key to the resolution of these cases yet, except for the Teladoc case, which is the one I mentioned earlier. That the defendant medical board's motion to dismiss was not granted in that case, in part because the court found that there was no adequate active supervision to establish state action immunity. So hopefully, as states start to add active supervision to their regulatory board's activities that have competitive impact, they will be able to get out of these lawsuits at the motion to dismiss stage instead of going through the time and expense of discovery to get rid of meritless claims at summary judgment. As these cases illustrate, many of the alleged antitrust violations in these lawsuits by the licensees do not state credible antitrust claims. The large percentage of the work done by these boards do not have any competitive impact at all, such as disciplinary proceedings for things like practicing while impaired by alcohol or drugs, sexual improprieties with a client or a patient, commingling funds, record-keeping violations or failure to provide a patient or a client with his case file, or failure to comply with continuing education requirements. And for licensing decisions, active supervision is not needed if the decision to license is based solely on objective, non-discretionary criteria, and there are no quotas or limitations on the total number of licensees for the state. These were issues that were somewhat raised in the Hoover v. Ronlin case that Geoffrey discussed, although active supervision was found there by the sovereign, which was the state Supreme Court. For the decisions the board makes that might have a competitive impact, such as advertising restrictions and scope of practice rules and certain ethics rules, the decision to add active supervision could be a cost-benefit analysis to determine whether the cost of adding an active supervisor and what would be entailed structurally to do so is worth it when balanced against the percentage of the board's total work that may have an impermissibly anti-competitive impact. Keep in mind when making that determination, though, that there are high costs to defend an antitrust challenge to summary judgment. Because if you don't have active supervision, you probably won't be able to get these cases out at the motion to dismiss stage. Antitrust cases are fairly complicated and usually require a full rule of reason market analysis, which entails weighing the efficiencies of challenge restraints against their anti-competitive effects in a defined product or geographic market. You might have to hire expensive industry and or economic experts. And the more defendants you have in a case, the more expensive this discovery is because there's more depositions, more document production. And in almost all of the cases that I had listed on the previous screen, the licensee sued not only the board, but many of the individual board members as well. Many have speculated that these are not the single disciplinary actions by boards are not the types of actions that raise the most anti-competitive concerns or need active supervision because of their limited effect on competition. And one of the things that was noted in the FTC guidance that Geoffrey was discussing is that reasonable restraints on competition do not violate the antitrust laws even where a competitor is injured economically. And as an example of that, they noted a suspension of a single licensee is unlikely to unreasonably harm competition. And then later on, disciplinary actions affecting single licensees typically have only a de minimis effect on competition. However, an aggrieved licensee often has the most incentive to challenge the board's decision to discipline him, and North Carolina Dental has emboldened these types of plaintiffs to bring these actions. So I believe that some clarification by the courts in this area is needed. And this can be illustrated by the Petrie versus Virginia Board of Medicine case. This case was filed in early 2014, which was after the Fourth Circuit's opinion in North Carolina Dental, but before the Supreme Court's opinion in that case. In the Petrie case, a chiropractor sued the Virginia Board of Medicine, the executive director of the board, and 5 of the members on her formal hearing panel in federal district court, alleging a group boycott. The construction of the board is statutorily dictated, but it is a majority of medical doctors on the board. The Board of Medicine actually regulates 16 different healthcare professionals, so there is not a separate chiropractic board in Virginia. The Board of Medicine and the individual defendants were able to have summary judgment granted in the district court because the plaintiff was held not to have antitrust standing under the Clayton Act. She was not able to allege harm to competition, only harm to herself. She could not show evidence of an illegal agreement and restraint of trade, and she could not show any competitive effects from her sanction. State action immunity was no longer relevant to this case because there's no antitrust violation underneath that needed to be immunized. The plaintiff appealed to the Fourth Circuit, and that appeal is still pending, but oral argument is scheduled for March 22nd. This could be an opportunity for a circuit court to limit the incidental holding somewhat in the single licensee disciplinary actions, even though state action immunity is no longer squarely an issue in this case. As far as I know, this is the first circuit court case on this type of issue since North Carolina Dental, so hopefully we will be getting some guidance there. There are several possible state responses to add active supervision. One is to reconstitute the board membership to have more public representation. But as Geoffrey pointed out, even if you make it so that the lay people are the majority and the active market participants are the minority, this incidental decision held that the relevant point was the controlling number of them, not whether it was a simple majority or minority. And he gave you a couple of examples where even a minority of active market participants could control decisions by the board. This approach then appears to be disfavored, and I have not heard of any states that are actually trying to address this way. One state, Connecticut, had a special legislative session in July 2015 and added some legislation to make all their board decisions advisory, at least initially. In that legislation, the commissioner of the Department of Public Health or his designee has the option to review every decision of its health regulatory board, but will probably only exercise that option for decisions on competitively sensitive issues like advertising restrictions or scope of practice decisions. The commissioner must notify the board within 15 days after one of the board's decisions that it is only going to be a proposed decision and that the commissioner's decision will be the final one in that case. I'm assuming that if the commissioner doesn't notify the board within that 15-day time period, then the board's decision will then become final. As you can tell, this only applies to the boards that are within the Department of Public Health, and most states have a lot of boards that are in more of the commerce and labor part of your state. So Connecticut is presumably working on some legislation to address those boards as well. Another approach has been an executive order of the governor, which Oklahoma did, and they issued Executive Order 2015-33. The executive order states that the rulemaking powers of the boards in Oklahoma already have sufficient safeguards in place through the Oklahoma Administrative Procedure Act and a previous executive order. The rulemaking is actively supervised by legislative committees and the governor, and these entities have the power to review, veto, or modify these rules, which is what the North Carolina dental decision holds. The executive order also sets up the Attorney General's office as the active supervision czar, or what a lot of us have been calling it, where you have just one office or entity in the state instead of having each department regulate its own board. That's going to be the active supervisor for the whole state. And that active supervision czar in the AG's office will actively supervise all board licensing and disciplinary actions. What the executive order requires the AG's office to do is to review and provide a written analysis of possible legal violations for these decisions. The board must defer to the Attorney General on any recommended modification or rescission of the proposed order, and failure to follow the AG analysis is considered misconduct and subjects the board members to removal for cause. As Geoffrey pointed out, a lot of states have held that this is not the optimal way to address these things. In most states, the Attorney General give legal advice only, and the agencies are not required to follow the Attorney General's advice. And so if you are not required to follow the advice, you do not meet the requirement for the active supervisor to be able to veto or modify the decision of the board. And then last, there's statutory fixes, which would entail legislation to add active supervision. Finally, I would just like to point out that some people have talked about judicial review as active supervision. That would be a situation where decisions by the boards can be appealed to the state courts, state circuit courts for review. There are two potential problems with judicial. It's not that you can't do it, but there's two potential problems with the incidental requirements. One of the incidental requirements is that the supervisor must review the substance of a board's anti-competitive decision. As Geoffrey pointed out, they don't have to engage in a full antitrust review, but they have to be able to look at whether or not the decision to displace competition that the board engaged in was one that was comports with the state policy to displace competition. So APA-type reviews that are limited to procedural issues, due process, fairness, or whether or not the board's decision was arbitrary and capricious, or whether a reasonable fact finder would find for that, probably are not sufficient. Also, even in situations where there's de novo review of the law or de novo application of the law, the factual record must exist below for the court to be able to evaluate an antitrust claim. So even if the court can apply the law de novo, the law can only be applied to the facts as they exist in front of the board below. The second incidental requirement for active supervision says that the mere potential for state supervision is not an adequate substitute for an actual decision by the state. And in cases of judicial review, the review is only triggered if the aggrieved party appeals the decision below. So in situations where the decision below is not appealed, there is a potential for the decision against the licensee by the board to have a chilling effect in that market, and that chilling effect will not have been actively supervised. That concludes my presentation, so I assume we might have questions.
Yes. Thank you, Geoffrey and Sarah. We do have one question. But before I read it, I will remind participants you may ask a question by typing it into the chat box. So our first question comes from Robert Quinnen. Here's his question. Is it important that the supervisor have the ability to modify the board's discretionary action? Or will it suffice that the supervisor vetoes and remands on any matter inconsistent with state policy, and potentially could veto any revised action in the future?
So I'll take that first. I have two thoughts in response to that question. First, the Supreme Court decision in NC Dental specifically references the power to modify as one of the powers that the court expects a supervisor to have and the ability to exercise. And second, if you're in a situation where the board presents its actions to the supervisor and the supervisor is told, in effect, accept our solution to the problem or there will be no solution at all, then that all or nothing choice circumscribes the discretion of the supervisor, and I think presents you with a problem that, again, you may end up with a policy that doesn't fully represent the intention of the state, but could be slanted in favor of the interests of the board.
That's exactly one of the issues that the Teladoc versus Texas Medical Board, one of the issues they found with the ability for judicial review to be active supervision was that they said the court had the ability to affirm and reverse or remand, which that included the ability to veto, but not the ability to modify. I'm not sure that I necessarily believe that, because if you can remand with instructions, I think that pretty much encompasses the power to modify. You know, I certainly would hate to go counsel any of my boards to go against the advice of the FTC here, though. So, you know, I think that's one of those areas that's not clear 100% yet.
Our next question is from John Alexander. He asks, you mentioned that sanctioning a licensee is usually not a problem. What about a situation where a board sends a cease and desist letter to a non-licensee?
Geoffrey, if you don't mind, I'll go first on this one. One of the things you need to keep in mind is there's a competing antitrust immunity besides state action immunity called Noor-Pennington immunity, which immunizes petitioning activity to the government or by the government that might otherwise be considered anti-competitive. So pre-litigation threat letters are considered immune under Noor-Pennington immunity. So if your cease and desist letter is properly worded, it doesn't say that the board has the ability to make you stop. It just has reason to believe that a violation has occurred, and that if you're going to keep going, they're going to sue you in the proper court. I think those would be immune. I think the cease and desist letters that the North Carolina Dental Board sent out were clearly not immune under Noor-Pennington. And Geoffrey, you can certainly expand on that.
Sure. So the facts in the NC Dental case were that the board sent C&D letters to non-licensees. So clearly the fact that the board is exercising its authority on non-licensees as opposed to licensees doesn't solve your antitrust problem. Perhaps what the question is getting at is, if you send a cease and desist letter to a single non-licensee, are you likely to have a substantive antitrust problem? And so in North Carolina, it was the antitrust problem or the competitive problem arose because a whole category of potential providers was being excluded. If a single provider is being excluded, then it may be the case that there is no harm to competition and there may be no antitrust violation. But that's really separate from the state action defense issues that we're addressing.
Okay, our next question comes from Jared Haynes. The FTC guidance reasonably points out that the active supervisor may need to independently review facts. However, one can imagine a wide variety of actions available to an active supervisor regarding facts, from accepting board factual findings to viewing record evidence to asking for more evidence from affected parties and or the board. Could either or both of you share opinions on what option is appropriate, perhaps depending on the context, like the type or magnitude of action being taken?
So,
yeah, go ahead.
My initial thought is that the board, in order to have plenary power and conduct a de novo review, has to have access to information or have the ability to get information that may not have been before the board, that the board should not constrain the information that's available to the supervisor. If your question is, should there be some proportionality between what's at stake and how in-depth the inquiry ought to be, then I think that's a sensible suggestion.
I think one of the issues you're going to run into here is that the Administrative Procedure Act in a lot of states prohibits the decision maker to look at any evidence that the licensee didn't have an opportunity to be confronted with and rebut. So that can go as far as even Googling stuff on the internet. So if the active supervisor in those type of situations feels like he or she needs more information, then I think the only recourse you have available is to remand it back to the investigating arm of the board with instructions to get more information on that, and then it's going to have to go back through the hearing process again. I'm not sure that was answering your question, but that's a concern that you need to consider as well.
All right, our next question is, in NC Dental, if the Dental Practice Act had expressly prohibited teeth whitening except by licensed dentists, would there have been a colorable antitrust claim?
So I've made the point that it's the exercise of discretion that needs to be supervised, and if the statute is sufficiently clear such that we can say that what the board is doing is not an act of discretion, that it's merely following directions, then the state, then I think the state action defense should prevail. And I guess I'll stop there.
Yeah, I agree.
Well, on that note, we're a little bit after 2 o'clock Eastern Time, and there are no more questions. So, Sarah and Geoffrey, I'd like to thank both of you for talking about this topic. It seems to me like we've come a long way in terms of what we know about NC Dental, and that we still have a long way to go. So thank you for sharing your insight from getting us from point A to point B. I think we all look forward to getting to point Z too. So with that, there is an evaluation that you all can complete related to this webinar. And again, thanks to Geoffrey and Sarah, and everyone have a great afternoon.